welcome to episode 24 of the Legal Scoop, our webinar series here at LOMAD, where we talk about recent wins by our attorneys or our staff. I'm Brennan Shannon. I'm joined today by my colleague, Neil Diegelman. Say hello, Neil.
Hello.
And Neil's here today to talk about a recent win that he had that I think will be useful to those of you watching at home, which is a schedule loss of use claim for the shoulder. Is that correct?
Right.
So why don't you just give us like the basic background details?
Right. So recently what I had handled was a schedule loss of use for a left shoulder injury that was at the time of permanency. The treating physician had opined that there were flexion deficits. He also determined first that special consideration 5 under the impairment guidelines applied to the shoulder. He also determined that special consideration 6 applied.
So let's break those down.
Perfect.
So special consideration 5, that's for surgical distal clavicle excision. Is that
right?
correct?
And so number 5 is you get some schedule loss of use for a distal clavicle excision and also for the single greatest range of motion deficit. So again, here we were looking at a 10% for the distal clavicle rescission, and then we were looking at an additional 25% for the range of motion deficit.
So a 35% schedule based on solely applying special consideration 5 and then adding the single greatest range of motion deficit.
Right.
Okay.
It sounds normal, sounds right.
Okay.
But here's where this case got incorrect. Is that then the doctor proceeded to go on to find that special consideration 6 applied, which special consideration 6 in general is the non-surgical rupture of the distal bicep tendon.
Yeah.
And that provides for additional schedule loss of use and addition for additional range of motion deficits. So thereunder, the doctor concluded that an additional 15% would apply to the overall schedule loss of use for a total of 50% using both special consideration 5 and 6.
Okay, so, and it sounds like in this case we had an argument that only one of those special considerations should apply based on the wording. Is that accurate?
That is absolutely accurate. So we came into the hearing swinging, arguing that the doctor failed to finish reading the sentence of special consideration 6, which quite literally says that it limits the schedule loss of use up to a 33 1/3% schedule loss of use. So sure, the doctor found a 15% schedule loss of use under special consideration 6, but when reading both the full sentence of special consideration 6, it yielded a higher than 33 1/3% schedule loss of use.
Mm-hmm.
We went in, argued basically that the doctor misapplied the guidelines, while the range of motion testing and findings we had no issues with, which briefly things there you're looking for, making sure the range of motion testing to the injured extremity is taken 3 times. The greatest value is used, not averaged, and as well as the contralateral limb, if it's not injured, we're also supposed to be looking at that. In this case, all that was fine. So really it came down to the application of the guidelines under the special consideration 5 and 6. In general, again, we argued that if we use special consideration 5, right there is a 35% schedule loss of use. You don't even need to look at special consideration 6 because special consideration 6 limits it to 33 1/3%. We had some additional arguments. We noted that we were fully expecting claimants' counsel to argue under the blue line of decisions in cases, which...
So why don't we talk about that a little bit? So I was going to ask if blue came up, but basically blue is a recent third department decision, I believe from 2022, that specifically dealt with the chondromalacia patella special consideration for the knee, which was something that we used for a long time to limit schedule loss of use findings to 7.5 to 10%, because the wording of it basically said, if you have chondromalacia patella, that's all you get in terms of schedule loss of use. And what the court said in blue is that that ruling is inequitable or not fair if it could also be said that another pathology in the knee caused or contributed to the claimant's lost range of motion. So what that has gone on to mean is that basically if a special consideration does not say that range of motion deficits or percentage loss of use points can be added for range of motion deficits, then you're limited to what the special consideration provides. And what it also goes on to mean is that if that special consideration provides for a certain diagnosis, and that is the only diagnosis that is available or that exists in that area of the body, the shoulder or the knee, then you're really limited to the schedule loss of use for that special consideration. Another way of thinking about it would be, say you injured your shoulder and you've got an injury, like you said, to the rotator cuff, and let's say there's a special consideration for the rotator cuff. If the claimant has loss range of motion, they can't get the special consideration and percentage loss of use points for the loss range of motion because the special consideration already provides for the rotator cuff. There actually isn't one for the rotator cuff specifically, but that's just kind of an example. But if the claimant had a rotator cuff injury and another injury or pathology in the shoulder, again, we're not doctors, we just play them on TV, and it could be said that that other diagnosis caused the loss range of motion, then there could be an argument for the special consideration percentage points and the percentage points for the loss range of motion. So it's something that comes up a lot now, and it sounds like in this case it came up in the sense that you could argue that both special consideration shouldn't apply because it was already provided for by special consideration number 5. Would that be fair to say?
That's right. That's right on. That's exactly what we did. And noted that the doctor doesn't get to pick and choose which parts of the special considerations that he's reading and picking and applying to the findings, which again, had the doctor finished reading the sentence at the end of special consideration 6, he would have seen that it was limited to a 33 1/3. But legally, everything, then he doesn't know the legal aspect. So
right. And then I guess the last thing we'll just point out for any adjusters watching this, what came up here in your case was special consideration 6 for the shoulder. Basically, if a surgical rupture or tear of the biceps tendon, or I should say, if a tear of the biceps tendon is treated surgically, there's now case law that says that you do not get that special consideration number 6, the percentage points provided for that if it was surgically treated. So it's just something to keep an eye on because it'll be interesting to see how case law develops on that issue as well. But Neil, that was a great win, and it just goes to show something that we've talked about a lot of times on this program, which is never take a schedule loss of use opinion for granted. Always have a professional take a look at it, an attorney. We're very good at it here. We're very comfortable with applying the guidelines. And a lot of times, like in Neil's case, you don't even need the doctor's testimony. You don't even need an IME.
right.
You just need to review it and then make an argument. So great win. Thank you for coming on, Neil. We will be back next month with episode 25. We're into our 3rd year of wins here at LOMAD to talk about the most recent wins that will come to pass. So if you are interested in that, please subscribe to our YouTube channel. We also have additional video series with Melanie Daly and sometimes Andrew Gould. So just keep an eye out for anything like that. And we will see you next month. Thank you.